Good afternoon, everyone. Thanks for joining us for our very first title insurance subsection Zoom program. As you all know, we had to cancel a lot of the programs we had scheduled this year because of the COVID-19 pandemic. But thanks to our speakers, they were able to put together an amazing program on a very relevant and interesting topic. I've been told that the program materials LACPA was not able to send them out to everybody, so you should be receiving them after this program is over with. The speakers worked very hard on the program materials, and there's a lot of very helpful information, so you'll be excited to get it when you receive it. Also, at the end of the program, we'll be accepting questions for the speakers to answer. There's a button on the screen that says Q&A. You can type in your question, and at the end of the program, we'll pick the most interesting questions and respond to those, because unfortunately, we may not be able to get to all the questions. Now, today's program is on COVID-19's impact on recording and indexing of documents and the legal consequences that it has. And our speakers today are Bill Lahr, Ryan Squire, and Anya Stanley. You should see them on the screen right now. Ms. Stanley is a partner with the law firm of Gibbs Giddin and has over 41 years experience in the title insurance industry, starting out as in-house counsel with Safeco Title Insurance Company and later with Tycor Title Insurance Company. Ms. Stanley has been with her current firm since 1986, focusing on title claims and litigation. And since 2013, her practice has become primarily expert witness and consultation, but she still handles title claims on a part-time basis. Ryan Squire has been practicing law for over 20 years and has been a partner at Garrett & Tully in Pasadena for over 13 years. He primarily handles real estate and title litigation, trials and appeals, and frequently serves as outside coverage counsel for title insurers. Mr. Squire is also certified by the State Bar as an appellate specialist. Bill is a graduate of the University of California, Berkeley and the University of Colorado School of Law. Bill was admitted into the bar in 1974. He was in-house claims counsel for Safeco Title from 1976 to 1980. And since then, Bill has been in private practice specializing in title insurance litigation. So without further delay, I'm going to hand over the program to our distinguished speakers.
Good afternoon, ladies and gentlemen, and welcome to today's LA County Bar Title Subsection program. The title of our program is COVID-19 Impact on Recording and Indexing and Potential Legal Consequences. So I'm Bill Lahr. My two distinguished panelists are Ryan Squire and Anya Stanley, who I believe are visible on your screen. This is our first time to do a program on Zoom, so welcome everybody out there on Zoom land. I never thought I'd be presenting a program from my living room in Pasadena, but here we are. And that actually leads us to what the topic of today's program is. So to give you a little bit of a preview, what we'll be talking about today, first of all, are the relevant rules of law that pertain to when a recorded instrument will impart constructive notice. And then we'll talk about the impact of the current COVID-19 situation on the various recorders' offices in California and how it has changed the way people normally record and search documents. And then we'll turn to legal consequences of those changes that have occurred in the recording system because of the COVID situation. So let me start with the relevant law that we will use as our backdrop to talk about what the consequences of the COVID situation are on our recording system. The basic concept that we wish to address is how constructive notice is imparted by a recorded instrument. There's a lot more detail on this that we can't go into today because of time constraints. And if you want more detail on how to determine if a recorded instrument imparts constructive notice, you can refer to our title insurance subsection program of the Los Angeles County Bar of November of 2019, which is an hour-long program with a lot more detail than we can give you today. And there's a video of that presentation available through LA County Bar. But the general concept that we want to think about today is that to impart constructive notice, an instrument must be recorded as prescribed by law. And that requirement is set forth in Civil Code section 1213. And the question, of course, is what does, quote, recorded as prescribed by law mean? And if you look at our outline in the program materials, it will cite probably the three best cases that explain this concept: the First Bank, Hochstein, and Lewis cases. And what they explain is that for a document to impart constructive notice, it must be indexed. And there must be a way for a person to search the title using the index to find the recorded document. So as I think most people know, the mere fact that a document has been recorded is not enough to impart constructive notice. The document has to be capable of being located by a title search, and the title search has to be done using the index. There's a series of government code sections starting at 27230 through 65, which explain in detail that it's the recorder's duty to index recorded documents. And the reason for that is so that there's a physical resource that people can have and go to perform a title search. The case law emphasizes that a recorded instrument does not impart constructive notice unless it can be located by a proper title search. And a proper title search, as the cases explain, is performed by using the index in a particular way. The relevant authorities also emphasize that a title search is actually a fiction. Nobody really does a title search. People use title insurance companies to determine what the content of the public records are. It's extremely difficult to actually do a title search. I've done them. I'm pretty sure Anya and Ryan have as well. But it's a very time-consuming process when everything is in order and is perfect. And as you'll see in this program, it's questionable whether it would even be possible under the circumstances we have now. As the Lewis case says, if the public is to be bound by constructive notice, there must be a way to find recorded documents. And that's why the index is so important. So if you're interested in, again, in how to actually do a title search, we'll refer you to the November program that I mentioned. And I'll just also mention that in that program, we pointed out there's a very big lack of applicable law in California as to the details of how you do a title search. We all know you have to use the index, but there's a lot more to it than that. And how it's actually done is still a fairly open question of law. But there are minimum requirements for a document to impart constructive notice, and two of the main ones are: you have to have access to the recorder's office's index, and you also have to have access to the full image of each recorded instrument that you find in doing your index search. That means you have to be able to read the entire text of every document that's referred to in the index. The index will just refer to the date, grantor, grantee, the general type of document, and the date it was recorded. You have to actually get the document to see what it says in order to properly search title. Also, there's authority that even if a recorded instrument within its text refers to another recorded instrument, the document being referred to is a document on which you are on constructive notice. So again, you have to read the documents. And as we'll see in a few minutes, it's not clear how easy that is to do right now. Government Code 27320 imposes requirements on the recorder for what to do when they record. They're supposed to actually designate the date, time, hour, and even minute that documents were recorded. Again, we'll see it's unclear whether that's possible now. So knowing that if you want to be able to record an instrument so that it can be found by a title search so as to impart constructive notice, how is COVID-19 impacting the recording and searching functions here in Southern California? And Anya is going to start next and talk about how that's happening in Los Angeles and Kern counties. Then I'll talk about Riverside and San Bernardino counties. And then Ryan will give us information about Orange, San Diego, and Ventura counties. So Anya, let me pass it to you.
Thank you, Bill. Start out with one of the handouts that we actually thought you would have our program materials. And so it's a little surprise to us that you don't have the program materials. So that's a little bit unfortunate. But one of the handouts that you will get after the program is a spreadsheet that was put together by the CLTA that shows the status of all of the county recorders in the state of California as of April 10th. And it basically shows that they're all closed. They are providing limited services, but the physical offices are all closed. And that is going to be a major problem, which we're going to get into more detail as we get into the 7 Southern California counties that we're going to talk about. In the handout, though, that the CLTA put together, there's one aspect that's a little bit misleading, and it talks about the access available to the general public. And this is access, they say that there's available for access by mail or online. And that's misleading because they're talking about access for things other than property records. And our focus is solely on property records. And you have to keep in mind that county recorders handle other types of records, such as marriage records, birth records, death records. But in our focus on our seminar, we're only going to be talking about property records. So the first handout is going to be the CLTA's records, and that's of April 10th. The second handout you're going to get in your program materials is one that we created, and that is going to be our survey, I suppose. We just basically called around, emailed, harangued, just bothered all the various, for 7 counties here in Southern California to get specific information that we thought was relevant for property records in Southern California. And the 2 counties that I have are in Los Angeles County, and I'm just going to hit some of the more important points for Los Angeles County, mostly LA, and also Kern County. Again, our spreadsheet goes into much more detail, but I'm just going to hit the highlights. As with all the other counties, the physical offices are closed. That means you cannot walk in to the county recorder's office. There's no counter service available, so you can't go in and present a document for recording. It also means you can't go in and conduct a search of any of their records. You can't access their computers to do a search. There are, for Los Angeles, now I'm just talking about LA County. There are only 2 ways to get a document recorded in Los Angeles County. One is an electronic recording, and that is available only to title companies. The only other way that's available, and this is for the general public, is by mail. The turnaround time for electronic recording is same day or next day. The turnaround time for recording by mail, and this is very bad news, 4 to 6 weeks. And that's from the date that the county recorder gets your document received by mail. In terms of indexing, the county recorder is telling us that they are indexing in their normal time frame. However, we have no way to verify that, so we're just going to have to take them on their word. A very important thing with respect to LA County is that there is no way, absolutely no way for anyone, be you the public or the title companies or anyone, to search their records. You can't search the index. You can't search the official records. No way, no how to search any of their records. The other thing in terms of certified copies, you can get certified copies from Los Angeles County. The request can be made online, and they will accept payment by credit card. They send the documents by mail, and they say that it's a 5-day turnaround. I think you should probably allow more time than 5 days, but that is what they are reporting to us. For Kern County, it is a much better situation. They again have electronic recording, but by title company only, same day or next day recording. For the general public, they are accepting recording by mail, but they also have a drop box. It's in Bakersfield. They are saying that they can do next day recording for Dropbox or by mail upon date of receipt. I don't know if that's really true, but that's what they're telling us. And they're also saying they're indexing on their normal schedule. Their index and their documents are available online. And they also have a public access computer available at a kiosk. There's an address that we have in our spreadsheet. They provide certified copies. Now the request can only be made by mail. They will only take a check or money order. You have to provide a self-addressed stamped envelope. They say we don't know what the turnaround time is. They didn't provide that to us. So now why don't we turn to Riverside and San Bernardino, and would be Bill.
Thank you, Anya. I'll give you some of the highlights of the current situation in Riverside and San Bernardino. We're very proud of our spreadsheet. I'm holding it up here. This will be in your program materials. This has a lot of detail on what each county what services they'll provide. So some of the main things in Riverside and San Bernardino, they were both closed to the public starting on March 18 and have remained so through now and will continue to be so. The only way to get something recorded same day or next day is if you use a title company to record electronically. And it isn't clear that title companies are available to simply record documents at the request of the general public. Certainly, title companies will record as part of a transaction they're handling, but immediate recording can only be accomplished electronically through a title company. Now, if you're talking about the general public recording documents, in Riverside, you can do it by mail or Dropbox. And we're not talking about the Dropbox app that you may be familiar with as an online thing. This is an actual box outside in front of the courthouse recorder's office with a slot in it, and you drop the document in the box. So you can either mail your documents as a member of the public or put them in the Dropbox. And in San Bernardino, they don't even have a Dropbox. You have to either mail or use FedEx. So that's the only way those two counties will allow a member of the public to record. If we're talking about Riverside, it's a 14-day approximate time lag from the receipt of either mail or Dropbox to get the documents recorded. In San Bernardino, it's 72 hours. Certified copies you can get from Riverside in 6 days after you've delivered your request by mail with payment, and in San Bernardino, it's 48 hours. Index availability and image availability. For the both counties, the way you accomplish seeing the index or actual images of documents is by starting at the county website, and the website addresses for both Riverside, San Bernardino are in the spreadsheet that's in our program materials. So once you're on that website, go to recording, and then that will give you choices, and you want to go to index search. In Riverside, it'll then divert you to a private company, Lexis, which gives you the option to purchase documents. And that's the only way you can really, well, you can look at the index. You can, if you put in the name that you're searching, it will bring up a chronological order of all the instruments that are recorded for that name, either as grantor or grantee. But to actually get an image of the document, all the index will tell you is the type, like grant deed or agreement or something like that, or a deed of trust. But to know what it says, you have to buy it from Lexis, and that's going to be $7 for the first page, $1 for every additional page, and $6 for the Lexis fee. So this really isn't even the actual index. The index is maintained by the Riverside County Recorder, and you see it by going into the recorder's office and going on one of their terminals. This is an alternative that's online and is available. Now in San Bernardino, you can get their index from the website process that I just described. And again, you input the name that you're searching, and that will bring up in chronological order all of the recordings in that name, showing whether that person is grantor, grantee, the type of the document, and date the document was recorded. But again, you can't see an image of the document, you have to buy it. I did a little test, and I tried to locate and purchase documents that I'm aware of because of cases I'm handling right now in both San Bernardino and Riverside. For San Bernardino, I put in the name, and in the index, I found the name, or when I put the name in, all the recordings came up. I found the document that I was aware of, and I bought it using my credit card on Sunday, and I got it yesterday. So that was pretty good. In Riverside, I did the same thing. I was able to get a list of the recorded instruments, but then when I went through the process of trying to buy the one that I wanted to buy, I wasn't able to make the system work. It said they didn't recognize my email address, even though I had it correct. So I'm not really sure what happens in Riverside. The only other way to get a full image of a recorded instrument in Riverside and San Bernardino is to order them by mail, and that takes quite a long time. So those are sort of the primary pieces of information about Riverside and San Bernardino that are different from normal. Ryan, what about Orange, San Diego, and Ventura?
Great, thanks a lot, Bill. By the way, can everyone see the PowerPoint? Is that working?
Yep.
Okay, good. Okay, so again, our materials, I understand, will be submitted or disseminated after the presentation. So you'll get our chart here that has all of the information and data that we're talking about. The Orange County Recorder's Office closed on March 17th, Ventura closed on the 18th, and San Diego closed on the 23rd. As with the other counties, title companies can record electronically. Not everyone is allowed to record electronically. The public can't record electronically. There are specific statutes and rules that prescribe who is allowed to record electronically. So only title companies can do that. And in my 3 counties, there obviously is no counter service available. However, the offices are still open. And Bill had raised an issue of a Dropbox, and in Orange and Ventura and San Diego, there is no Dropbox. So the only way to record something is either through a title company, which can record electronically, or to mail in the document that you want recorded to the Orange or Ventura or San Diego recorder's offices. The Orange County office is processing mail daily like normal, but some of the information we got was that even though they're processing it daily, that doesn't necessarily mean that the documents are being recorded as received. In Ventura, the recorder is processing like normal, and we're told anyway that documents are being date stamped as they come in and as are processed. In San Diego, documents are also, we believe, being date stamped as they come in, and mail is being processed daily as usual. But again, this does not necessarily mean the documents are being recorded as received. Keep in mind, again, there's a lot of confusion going on with everybody about how documents are being recorded and what's happening when they get to the recorder's offices. Also keep in mind, I found an interesting statistic online. San Diego typically records about 60,000 documents a month. So, you know, we're talking about an awful lot of pieces of paper or electronic documents that are getting recorded in any one month. So it is a lot of information, and naturally we've got to be patient with the folks at the recorder's offices. In terms of whether the documents are being indexed, Orange tells us that they are indexing documents, Ventura is indexing documents, and San Diego is as well. Orange is telling us that it is indexing them normally, and that takes about 2 days. That's a two-day indexing time after the document is recorded. So we'll talk in a moment about how long the entire process takes, but after a document is recorded, the lag time for indexing is about 2 days. In Ventura, again, normal time frame for indexing documents once those documents are recorded, and the same is true in San Diego. And San Diego tells us that once a document has been recorded, the normal time frame is a day or so to index a document. Now, are there official records available to the public in Orange County? Yes, document images may be purchased online or by mail. Online is the fastest method. In Ventura, they can be bought by mail or a third-party vendor called vitalcheck.com. Again, that'll be in our materials. And then in San Diego, official records may be purchased, that is, the images themselves may be purchased by mail. It doesn't look like at this point that you can buy it online. But again, I think as we may have mentioned earlier, and as you'll see at the top of our chart, we have sort of a caveat because this spreadsheet was prepared based upon information that we gathered, several days ago, and things are changing regularly and frequently. So be sure to check, obviously, with the county recorder. I don't remember if Anya mentioned this already, but be sure to check well in advance before you need to record anything, what the current process is for recording. In terms of the entire process and the amount of time that is being required in these various counties, in Orange County, the entire process, including processing the recording, the document, indexing it, and then returning the original to the person who's recording it, is supposed to take about 7 to 10 days from receipt. That's what we're being told. In Ventura, we were not given a time frame for a turnaround time. In San Diego, we're told that the entire process takes about 1 to 2 weeks from receipt. And so obviously there is going to be somewhat of a delay from when the documents are received, if they're received by mail as opposed to electronic recording. If they're received by mail, there is obviously going to be somewhat of a delay of a few days, probably 1 to 2 weeks for these 3 counties anyway, before the documents are fully processed. The question, again, is whether or not it's possible to get certified copies. Yes, you can, typically by mail or online in certain counties that permit that.
Before we have this area, I'll address it to Bill and Ryan. What did you find when you were making inquiries as to how the recorder's offices were keeping track of the receipt of documents coming in by mail or those that have drop boxes in terms of the date of receipt at the time of receipt? What information did you find out when you were doing your investigations? Bill, why don't you answer first?
As to Riverside and San Bernardino, the information they gave us is that they are keeping track of the day everything is received, meaning the day that things are dropped in the Dropbox or the day the mail is received. But they were not able to answer our question about whether they are actually selecting a particular time of day to attribute to the recorded documents. So I believe the recorders are only giving a date for receipt. And then I don't know, and they weren't able to answer this either, whether the date of receipt will be the date stamp as the date the document is recorded, or if they will treat the recording date 10 or however many days later it takes them to actually take the document they received and get it recorded. So that part's not clear.
What did you find out, Ryan?
More or less the same that Bill found out. And unfortunately, not a whole lot of concrete information about when the recorder is stamping documents, if it is stamping the documents, and how it's determining what documents are received before others. I think in some counties, maybe they're segregating them by day so they know what's coming in, but it's not clear to us how the recorder is determining that some documents have come in before others. Now, presumably, if they're receiving them by mail, I guess maybe they receive the mail all at the same time. I don't know if they receive them more than once per day, that is the mail once per day. But in any event, there is an issue out there that is going to have to be addressed at some point, and that is when documents are submitted and received by the recorder, which documents were received and processed before others. So it's an issue that is going to have to be addressed at some point.
We found out the same thing.
I might just mention on
the answer when we asked Los Angeles, it was basically, we work on the documents that we have in this one stack that's one day, and when we're done with those, we move on to the next day. And we don't even know if they're date stamping them. We got the vaguest of answer. And Kern County were extremely meticulous. They were date stamping everything. So we don't know though if they're doing a time, and I can't see how they could do a timestamp for things that are coming in by mail or Dropbox, because again, they're all going to be coming in at the same time. So I think it's going to be very interesting as we get in later in terms of talking about the legal consequences, and the timestamp is going to be significant, I think, for priority purposes. We'll have to see how this all shakes out down the road, but I just don't see how they could be keeping track of the time that the documents are coming in.
And Anya,
to the legal consequences of some of these things that are going on now with the county recorders.
Sure, thanks, Anya. Before we do that, Bill, I think you wanted to add something.
well, yes, I just wanted to sort of add to what Anya was saying. The case law, and particularly that first bank case that's in our program materials, points out the title companies have a method of bringing all their documents to be recorded to the recorder's office every day before 8 in the morning. And everything is recorded stamped as if it was recorded at 8 a.m. And by law and by case law, those recordings are all have equal priority. But if you have a document that's recorded later in the day, the one that's recorded earlier in the day has priority over the one that's recorded later in the day. So the time of recording can determine priority.
Right. And so I think one thing that we don't know at this point, or at least we were unable to determine, is when the recorders are receiving these documents by mail or Dropbox, as it were, how do they know the order that the documents were, say, put in the Dropbox? Is somebody sitting there and taking them out of the Dropbox as they are deposited? And is the recorder waiting until the end of the day and then just stamping everything with the same time stamp and date stamp. And so I think that's issues, again, that are going to have to be decided and figured out at some point. All right. Anything else, Bill or Anya, on that before we move on to constructive notice?
No.
Okay, great. Okay, so let's talk a little bit about constructive notice and bona fide purchasers. We've got BFP'S on here, but we also intend this to apply to BFEs, which would be bona fide encumbrances, not just purchasers. So an encumbrancer obviously is someone who is getting a lien or encumbrance against the property. The same general rules apply. Now, keep in mind that I think, as we've mentioned before, we're spotting issues here that don't always have answers. And there are going to be a lot of different scenarios that will come up. And so we hope that some of these issues that we're spotting for you will help you in the future. But again, these questions of constructive notice and bona fide purchaser are factually driven. And so there are going to be different factual scenarios that apply in each context. So let's talk about constructive notice a little bit more. Constructive notice, there is no constructive notice until a document is indexed in the grantor-grantee index. And there are lots of cases that say that, but the one that we've cited in the materials that you'll have is the First Bank versus the East-West Bank case. And so again, simply depositing a document with the recorder's office is not enough to impart constructive notice. It does not impart constructive notice until the recorder indexes it in the grantor-grantee index. Now, keep in mind, again, Bill did a whole seminar on this before for the county bar, and that's available for those who want to dig into this deeper. But the index is not an index of properties per se. It's an index of names. And so depositing, again, the document with the recorder is not enough. Somebody's got to go through the actual grantor-grantee index and trace out the grantors and the grantees to find out who has an interest in real property. And that's going to have some impact, as we'll talk about in a minute. So let's just briefly review the rules. Bill talked about them before, but let me review the ones that pertain specifically to constructive notice. And again, this is out of the First Bank versus East-West Bank case. That's a great case, summarized the law regarding these issues. So we have a race notice system of recording here in California, which means in general, the person who records first without notice or knowledge of somebody else's interest is going to prevail. Now, there are obviously permutations and machinations, but that is the general rule. And so the three primary criteria for determining whether somebody is a bona fide purchaser is whether they have acquired an interest, they've paid value for that interest, and are they on constructive notice, or do they have actual knowledge of a prior interest in real property. So that's number one. You've got to acquire your interest for value without knowledge or notice. And we'll talk a little bit later, but constructive notice comes by way of indexing. The second requirement is that what we're talking about here is you've got to have constructive or actual notice of a previously created interest. That is something that already exists. I'm sorry, you need to not have knowledge or constructive notice of a previously created interest in order to be deemed a bona fide purchaser. And the third requirement in order to be deemed a bona fide purchaser is that you have to first duly record your interest, which means that, again, you've got to get to the recorder's office before somebody else does. First duly recording means depositing with the recorder. It does not mean indexing. So what's interesting about this rule for a bona fide purchaser or bona fide encumbrancer is you've got to be first to record, which means depositing it. But then in terms of constructive notice, you have to lack constructive notice of a prior interest, and constructive notice only occurs by way of indexing. I mean, I guess it can, obviously we'll talk a little bit later about that, but it can occur through other ways, but primarily through indexing. So there are a couple of ways then that delays at the recorder's office could impact whether someone is a BFP or a BFE. Obviously, the first one is who records first. When you've got a situation where the recorder's office is delayed in processing documents that it receives, there is going to be an issue about when somebody deposited that document with the recorder's office before somebody else. And so there may be issues in the future where somebody can try to prove that the fact that the recorder stamped a document with a specific time and date stamp is not necessarily the date that the recorder received that document, and perhaps that document was received prior to another document that was also received or sent by mail. And so the question here is going to be not merely when the recorder stamps and dates the documents, but when did the recorder actually receive them? And it may be, again, that the recorder receives a document and actually stamps it for a different day at a different time. And so those are issues that you're going to want to look at if you get into litigation on these issues. Then there's the question of constructive notice, and that is indexing. And if there's a delay in recording, then a person cannot be a BFP or a BFE if someone else records their interest first. That's just the race notice rules. And then if there's a delay in recording, there also will be a delay in indexing. And if there's a delay in indexing, then there's going to be a delay in constructive notice. And then the question becomes, and I think Bill alluded to this earlier, if indexed documents cannot be searched or found, then would those impart constructive notice? For example, if there are documents that are indexed, and let's say that you can search the online index, but you can't look at the documents themselves online, you've got to order them, to what extent are you on constructive notice of the documents? Now, if you can order the document online, then the court may very well find that you are still on constructive notice or inquiry notice even of a document. And so these, though, are questions that will need to be addressed at some point, and that is whether or not the documents were properly indexed and whether or not someone could find the document, whether they had actual the ability to search and find the document itself. Let's talk for a second about trustees and bankruptcy. Given the economic downturn, we're obviously going to see more bankruptcies, most likely. The Chapter 7 and Chapter 11 trustees are hypothetical bona fide purchasers, which flows out of the strong arm power under 11 U.S.C. Section 544 of the Bankruptcy Code. And that gives the trustee the power to avoid any transfer that a bona fide purchaser could have avoided under state law. So, for example, if you have an unperfected lien or an unperfected transfer that occurs, or that doesn't occur, if you will, before the bankruptcy is filed, then the bankruptcy trustee will be considered a bona fide purchaser and will take free and clear of that instrument as of the date that the bankruptcy is filed. We'll talk a minute about a couple of exceptions. But first, I wanted to mention this case that came out about 10 years ago called In Re Dual that some of you may be familiar with. That's 594 F3rd 1073. In that case, the schedules were filed simultaneously with the bankruptcy petition, but the court essentially found that the schedules were filed a nanosecond after the petition because the petition had to be filed before the schedules could be filed. And so the question in that case was, well, there was an unrecorded lien that was disclosed in the schedules, and the court said, well, because the schedules were filed a nanosecond after the trustee became a bona fide purchaser, the trustee was not on notice of the unrecorded lien. And Dual also rejected an equitable subrogation argument where the lien that the person was trying to step into the shoes of had already been reconveyed of record as of the petition date. Now, there are some exceptions to the 544 rule of the Bankruptcy Code, and there is a grace period under 11 U.S.C. Section 547, subdivision E, which explains that a trustee is bound by liens and deeds that are not recorded as of the date the petition is filed, if those liens, the trustee is bound if those liens or transfers are recorded within 13 days of their execution. So you could have a scenario where the trustee where a deed of trust is executed, it is sent out for recording. It doesn't get recorded for 30 days. In the meantime, there's an intervening bankruptcy, and the bankruptcy code will say that that lien is valid and that the trustee is bound by that and cannot avoid that. There is also a 15-day grace period for trustees' deeds upon sale, pursuant to the Bebenisi-Wong case, which is a Ninth Circuit BAP case, 248 BR 820 that came down a few years ago. And that flows out of the rule that says under the California Civil Code section 2924H subdivision C that the trustee's deed upon sale must be recorded within 15 days after the sale. So there are a couple of exceptions under the bankruptcy rules, but be aware of the issue that trustees may very well be looking for ways to avoid liens and transfers that occur and that are not recorded because of delays in the recording process. Okay.
I think we're going to have to move quickly on our program material because we need to leave some time for questions and answers. So let's move on to alternative ways to give notice if we're focusing on the fact that constructive notice may or may not be as solid as it normally is. Why don't we quickly address alternative ways to give notice, and who wants to hop in on that particular topic?
I'll talk about that briefly, Anya.
Okay.
As Ryan just pointed out, the bona fide purchase, bona fide encumbrancer concept is highly significant because if you can say you purchased an interest in property without knowledge of someone else's interest, you have the superior interest. So if you can't get notice by recording, are there other ways that you can get actual notice and be bound? And there certainly are. Actual notice is a perfectly acceptable substitute for constructive notice. So we listed some ways to get actual notice in our outline. Some examples are if you're looking at a non-judicial foreclosure sale, you can actually go to the sale and announce that you have an adverse interest at that time. And it's a good idea to take your cell phone with you and have somebody video you making the announcement for evidence. You can use personal service if you can find a competing interest holder, or try to serve them by mail using a return receipt. You can post the property with some sort of notification. You should be mindful of the party in possession rule of Gates Rubber v. Ullman. If there are people in possession of property, you're charged with notice of what you could find by inquiring of those people. And then there's the general inquiry notice concept of Civil Code section 19, which is if you have knowledge of facts which would cause you to inquire and learn other facts, then you're charged with what a reasonable inquiry would disclose. So these are all alternative ways to impose notification on someone when they might be claiming, well, I searched the records, but I wasn't able to find a recorded interest.
One of the things that I wanted to just briefly mention, and that would be an impact on litigation, is one is just sort of a no-brainer that when you are doing litigation, just keep in mind that you're probably going to have a delay in getting certified copies. So give yourself lots of time to get your certified copies. The other thing is, at least in Los Angeles County, is if you're going in for a TRO and you're going to have it, and the judge is giving you a hard time saying, oh, well, maybe you should just go get a lis pendens. I think that we've probably given you enough information here to know that you can't get a lis pendens. I mean, you're not going to get a lis pendens in Los Angeles County. You'll probably get your lis pendens recorded about the same time that the recorder's office is going to be reopened. So I think you have a very effective argument here that a lis pendens is going to give you no protection whatsoever in Los Angeles County. So now I want to just ask the panel to address a couple of issues in terms of how all of this is affecting the title insurance industry. And Ryan, why don't you address gap coverage?
Okay, great. I'll do that quickly. So we took a look at the homeowners 2013 policy and the ALTA loan policy from 2006. And both of those provide for gap coverage. Let's quickly define what gap coverage is. Gap coverage would be coverage for things that occur with respect to title between the date of closing and the date that a deed or deed of trust is recorded. And you'll find the loan policy actually provides this as covered risk number 14, and it talks about any defect in or lien or encumbrance on the title that has been created or attached or has been filed or recorded in the public records subsequent to the date of the policy, which is normally the closing date, and prior to the recording of the insured mortgage. And then in the homeowner's policy, it's not actually found, this coverage isn't found in the covered risks. It's actually part of the definition of policy date, which is condition 1. And the policy date is defined as the date that the insured acquires the interest that is insured by the policy. And so it says that if the policy date is the closing date, but the insured doesn't record his or her interest for a week or day, 2 days or 10 days later, the policy date becomes the date that the document is actually recorded. That is the date on which the insured acquires their interest, even if the policy date listed in the policy itself is something different. So this is something that could come up with delays in recording. Obviously, the title insurance companies are recording same day, so they're able to be assured that documents are being recorded, but nonetheless, these provisions could be triggered.
Yeah, that was a funny thing. When we asked around to underwriters, we found out that they weren't concerned at all about gap coverage because they were recording same day or next day. But what they did say they were concerned about, or at least had mentioned many times, was loan modifications, because many of the lenders are getting requests from their borrowers to modify the loans because they're extending or doing a forbearance on the payments for a month or 3 months, or changing giving them not requiring interest payments, or changing the requirements on the payments. And the lenders have been asking them to give them endorsements on the loan policies. So we decided that we would include in our program materials some sample endorsements. Some of the title companies have put together special COVID-19 loan modification endorsements, which really aren't really new endorsements. I think it's more of a marketing thing that they put together for marketing purposes. But we put together a little sampling. We have what First American is offering, and we have what Fidelity is offering, and then we have what Old Republic didn't put together a special one, but it's their normal loan modification endorsements, which are just as good as the special ones. So we just have a few samples of loan modification endorsements. So I think that that's all of the prepared material that we have, and I'd like to now open it up for questions. And how are we going to handle the questions now? Bill, are you going to handle it, or no, Elmira, you're going to handle the questions, right?
Yeah, I'm going to go ahead and handle that part. Do you hear me?
You sure can.
Yes.
Okay. So there's one question which I thought was interesting, and I don't think you covered, is will a mechanic's lien mailed to the recorder's office on the last available day still be effective even if the lien is recorded days or weeks after the date of mailing?
Well, I'll take that one. Obviously, it would depend on what county you're in. If you're in Los Angeles, I think you're going to be in a lot of trouble with any of the types of recordings that are time sensitive. And I think that more likely than not, you're not going to make your time sensitive recording date. Whether or not a court is going to basically give you a tolling on this, I don't know. But I don't think that you're going to make your time statutory recording date. I think the court's going to say you didn't make your date. We actually, I will say this, nobody knows the answers to any of these questions. And it's all going to be virgin territory out there in litigation. But I think that the court is going to, I think that the first answer is going to be, it's going to be the date it actually gets recorded. And I think that if you're recording it by mail, and you would have to do that as a member of the general public, you're not going to make your date.
There is at least maybe one argument on it. I don't know if you necessarily agree with this, but maybe somebody could say, well, even if it wasn't recorded for 2 or 3 weeks, it was deposited with the recorder's office because the recorder received it by a certain day, by the required day, even if they didn't process it. And it's not my fault if they didn't process it. So there is at least maybe an argument there that it was deposited within a timely fashion.
Well, that's the only argument you can make.
Yeah.
And maybe it's good enough. I don't know.
We'll find out.
Yeah,
There's an appellate argument
definitely.
the trial judge might have said that you didn't record it on the day it had to be recorded, but then you do have the argument there, I couldn't. It wasn't possible.
Definitely.
Right.
So another question that multiple people have asked is, do title companies and their title plans have access to documents that have been recorded and indexed after the closure of the county recorder's office?
It's a great question. Anya, I think you actually talked to some title people about this, right?
Yeah, I know the answer to this. They would not have access to the index, but they will have access to the recorded documents.
Right. But what we're still finding, at least, is that the plant dates that are shown in the preliminary reports are perhaps older than they ordinarily would be. And so I guess there's a question as to whether or not an effective date down can be done between the date of the preliminary report and the date of the closing. Anya, I don't know if you have any thoughts on that, but it seems to me that there's a potential risk there that documents could very well be missed.
Well, you know, I'm getting inconsistent answers on that. First of all, we should define plant date because not everybody knows. The term plant is the term that's used in the title industry for their own proprietary database, which is where they maintain their own proprietary copies of recorded documents. There is always going to be a gap in the terms of how up to date their plant is from when the actual recordings are. The plant date can be, normally even, you know, without a pandemic, there's usually going to be a little bit of a gap. It could be 3 or 4 days, it could be a week, and that's normal just on a day-to-day basis. And title companies are comfortable with that, and they usually close transactions just on a risk basis. But I'm being told that their plans are acceptably up to date. Now, however, of the preliminary reports I have seen since the county recorder's offices have closed, all of the dates shown, you know, the as of dates on the preliminary reports are all predate the date of closing of the recorder's offices, and I don't understand that. And I've asked each underwriter of the counties that have issued those reports, what's up with that? And they say, oh no, our plan's up to date. So I do not know what's going on that.
Okay, so I have a question that's being asked by one of the attendees that I asked Ryan too. Ryan, they want to know if you read all those books that are behind you.
Every single one of them, twice.
So I think you guys covered most of the questions already in the presentation, but there was one other question I think which we should respond to is, are title insurance companies providing any certain exceptions in their policies resulting from the lag in the recording times?
Well, that's the gap coverage that we were talking about. I believe most of them are providing that coverage. So they're not. The answer would be no. They're not taking any exceptions to my knowledge.
Right. I mean, it may depend on the policy that you get. Different forms of policies have different coverages available, but if you get one of the most current policies like the 2013 homeowners or the 2006 loan policy or the 2006 owner's policy, they should afford that gap coverage.
And the last question that we have is, will title companies provide any services to the general public if they want to record a grant deed or any other document on their behalf?
Without insurance, is that the question?
Yes.
I might mention, my information is title companies are not generally willing to do accommodation recordings right now.
That's my experience.
You have to be part of a transaction with that company, or I'm not sure they'll just be willing to record your document by walking in off the street. Anya, Ryan, you know any?
I tried to get a document recorded as an accommodation in Riverside County, and I went to every title company that did business in Riverside, and nobody would do it.
I think we're having, yeah, I think that we're finding the same information across the title companies. It may depend on relationships, but you know, we have the issues of whether or not the title companies are going to record these as accommodations, and we all know that there are issues that arise when those requests are made and when that happens. So it's something that could spawn future litigation, frankly.
And I guess one last question we have is, are the recorder's office still processing subdivision maps for filing?
I don't know the answer.
I don't either.
I mean,
I don't know of a reason why they wouldn't be necessarily, but I'm not aware that they are.
Right. My interviews are that they're doing everything that they always did, but it just takes longer. That's what they tell me. But there's no service that they previously provided that they don't provide during the COVID problem. It's just they do it in a slower way.
Okay.
And
I think
by the
those
way,
are all the questions, and our time is up.
I was just going to say,
Go ahead, Ryan.
Yes, sure. Thank you. I was just going to say, if anybody else has questions that were not answered, I'm sure Bill and Anya and I would certainly be glad to discuss any other questions or try to help or answer. If you want to email us, probably the best way to get a hold of us. And
Absolutely.
yeah.
Well, thank you guys for the presentation. It was very insightful and informative, and hopefully it answered a lot of the questions that all of us have. And again, thank you all for registering for the program. I hope you enjoyed it. I'm signing off.
Thank you very much.
Thanks, everybody.
Thank you.